substantive day of class. This is our last learning day.
Yeah.
Okay. So our exam is on Monday. In class, it's exam 3. It's non-cumulative. It's going to cover everything that we've learned from since our last exam until the end of today. So what you're responsible for, that's what you're responsible. So what we leave off today is where the material ends for purposes of your exam. With that in mind, I reordered and revised your PowerPoint for chapter 44 to make sure we get to what I think is the more important content, which appears at the end of the chapter, so I pushed that to the front of the PowerPoint. So we're going to address all those topics. If you have questions, bring them. You'll note that I did input grades yesterday, and we're still kind of working through it, but it's a labor-intensive process and a very high impact semester going on, so there's a lot of various messages I have to go through to make sure everything's in. But my goal is to make sure that you're graded for your effort, and so for some reason we feel like there's an assignment that wasn't graded. It was submitted, it was graded in the next but any disconnect whatsoever, now is the time to bring it. We can have that conversation. You may accomplish a goal, you may not, but we can have a conversation and be on the same page. That's what's important, right? So that we, there's no surprises when the grade is posted. For your exam on Monday, bring a large grade book. It's going to be a fully written exam. You have a reference sheet, both sides of one page, 8.5 by 11 piece of paper, works for me. I want you to write intent on your exam, so bring pens. You may write on your exam, so bring highlighters, whatever it is that you need that will help you. It's going to be come promptly. I'll be early. If everyone's here and ready to go at 11 o'clock, you start your exam at 11 o'clock, right? And you can have a full 75 minutes for your exam. I'm going to write a 75-minute exam. I hope that you all will finish it. That's the intention when I write it. So I think it'll be about as time intensive in terms of pressure as the answers to the practice quiz I left on the photocopier upstairs this afternoon. So I'm going to email it to you through a Canvas announcement. So you'll see the answers to the practice quiz that you guys did, that pre-test that we did before we started corporations. You'll see that as a Canvas announcement attached there too. And if you have questions about it, we'll send them to me via email. I will be here on Friday afternoon. Not 1,000% sure the hours that I'm here will largely depend on what I have to do out here and when the students who have contacted me communicate that they will be here and it works for them. So pretty flexible. I hope to be here tomorrow afternoon. I'm not sure if it's going to work out. We still have some meetings and some things that haven't been fallen into place. But I am available. If you have questions, email me. If you want me to review any work you've done, you want feedback on something, email it to me. I'll give that to you. If you want to have a call, we can do that too. That's fine. I can do that. So I'm available for you. Also available for you are our tutors. On our BLAW website, go to the website and click on the tutors. Free tutors. Expanded hours this week and next week. So it's not just to them. I would highly recommend it. For example, if you struggled with that essay on the practice test, that would be something to take into the tutors, talking about it. Take the essay, take your answer, and have them critique it with you. Because we can go through it, but when that peer-to-peer input is received, it's usually way more beneficial. Plus, these tutors are my previous students. And so they can tell you, oh, this is what she means when she says that, like, or whatever that communication disconnect may or may not be, right? So I want you to have access. So the tutors are a wonderful resource for you. Okay, you guys ready to go? Ready to go? Everyone's ready to go? There's a lot of movement and commotion. Let's go. All right. So this is where we're going to start off again. You guys have learned a lot about fiduciary duty, but I want you to be super clear on how we evaluate whether or not there's been a breach of fiduciary duty in the context of a director or an officer, their behaviors, their actions, their decision making. We constantly make choices. You guys are making a choice right now. You made a choice in the class. You're making a choice whether or not you're taking notes, whether or not you're paying attention, whether or not you, whatever you're doing, right? You'll constantly make choices, and you're not even aware of the choices you're making, right? So in their day-to-day activities, the officers who are managing the business, daily business, right? They're making constant choices. And when are those choices a breach of fiduciary duty? When do those choices harm the corporation? This is how we decide using this test. Now, do the directors manage the day-to-day operations of the corporation?
No.
No, not unless they're an officer, right? So officers manage the day-to-day business. But they could both be liable for breach of fiduciary duty in connection with the choices they've made or the actions they've taken. So here's the test. Board members and officers shall act, one, in good faith, in a manner the individual reasonably believes is in the best interest of the corporation, and, so all three have to be satisfied, and with a care that a person in a like position would reasonably believe appropriate under the circumstances. So what this requires, that care, what care would you take? Take great care. What care would you take? Usually requires some sort of investigation, hiring a consultant, appraising the facts, gathering all the facts before you make a decision, making that informed decision. So it requires reasonable investigation and honest belief that the acts are in the best interest of the corporation. So this is a three-part test. When you look at those choices that are being made, the choice to declare dividends, the choice not to declare dividends, the choice to shut down this factory, the choice to fire 20% of the workforce, the choice to hire 20% more workforce, the choice to suspend a product line or to launch a new controversial product line or to start advertising your hot tubs with chorus choirs, right? Like all those different choices, those various types of choices, all those different things are analyzed with the same test, right? Did it harm the corporation? So, you know, is it a breach of fiduciary duty? You have to satisfy 1 through 3. And again, the reason why I put this point here is that gathering all those data points, gathering all that information is what's required in order to make a meaningful decision. You could have made the wrong decision. Hindsight's 20/20, we make mistakes all the time. You can make the wrong decision. It won't be a breach of fiduciary duty unless this can be proven. So, the test is evaluated based on the facts presented at the time the decision was made, not hindsight. So at the time the decision was made, based on that information, was there a breach of fiduciary duty? Not in hindsight. Of course, fast forward 2 years and it's a disaster and you're like, why did you do that? That was so bad, right? But that happens all the time. I mean, I know I make choices that 2 years later I'm like, oh, why didn't I do that? So we all do it. It's foreseeable. It's foreseeable. Negligence is foreseeable. We're human. We make choices. But we can't have the benefit of this, future knowledge when we think about whether or not it's a future duty. Because the person who's a decision maker doesn't have a crystal ball. They don't know how it's going to turn out. They're just working with what they have in that moment. And so it's really, really easy to get into a fact pattern on the exam, in the book, or in life, where we want to place blame on some sort of actor or decision maker because the outcome was disastrous or just not as good as you had hoped for. But you can't establish that there's any true liability unless at the time that choice was made, this test is satisfied, right? At the time the choice was made, was the person acting in good faith? Did they reasonably believe that this choice was in the best interest of the corporation? Did they act with care that a person in this position would act with? Did they conduct a reasonable investigation? Did they discuss it? Did they talk about it? That's what's necessary. If you do all this, and you still make a mistake, that's fine. It's not to breach of fiduciary duty. It's just being human, right? But if you can't satisfy this test, then you can possibly be held liable for breach of fiduciary duty. So, breaching the duty of care. If you're liable for a breach of duty of care, right? So this is a standard we expect. If you don't meet the standard, whatever losses that the corporation incurs, that's what you're liable for. That's not you, because you guys would never make mistakes. You meaning like the figurative you, the figurative director, the figurative officer who makes some sort of mistake that's catastrophic for the corporation, they would be liable to the corporation for losses. So the corporation loses $10,000, they would have to pay that to the corporation. So those are the damages. And when you end your analysis, you always want to end with like the resolution, right? Is the person liable? Yeah, the person's liable. And this is what the corporation can recover as a basis for that. Like, what's the whole point of proving someone liable? It's to establish how they're going to make you whole again, right? How they're going to fix that. If they're liable, it can't just stop there. It's like, well, how do they repair? How do they restore? And that's the damages. That's how you end the discussion. That's how you bring it full circle. All right, so the business judgment rule. This is another, I think, extension of that concept of you have to look at the choice that was made in that snapshot in time. What information did they have available to them? And did they make the best choice that they can make given the information that they had, right? Given the fact that we don't have crystal balls that will tell us what's going to happen as a result of our choices. So the business judgment rule protects directors and officers. It's used defensively. It protects them. It says that absent bad faith, fraud, or breach of fiduciary duty, remember our previous slide talks about how you meet your fiduciary obligation. Right? The judgment of directors and officers is conclusive, meaning the court is not going to, after the fact, right? You go to court after a problem happens, after the resolution is disastrous. Someone sues you, goes to court. Then the judge is there looking at the facts the person had and the outcome, and like, oh, this is a big mess. Like, right. Is the judge going to substitute his judgment and say, well, if I were you, I wouldn't have done that, and so I'm going to hold you liable? No. The business judgment rule basically recognizes that judges are former lawyers, and lawyers are deal killers. Right? Why do I say that? Because we appreciate and advise parties regarding the risk of a transaction, right? The whole point of what you're learning to analyze both sides and make informed choices is because you want to figure out a way to appreciate and establish, articulate the possible risks and benefits of each course of action. And what lawyers do is they think of all of that. So when a client comes to me and is asking me about X, Y, Z, I have to say, okay, well, here's the pros that I see, and here are the cons, and here's the potential liability exposure. And then what that business person does is it takes that information, that potential liability exposure, and what they see as the potential payoff, and they make an informed choice. In light of this risk, am I going to do this? Right? In light of this risk, am I going to do this? So lawyers appreciate the risk, and frequently are risk averse. So a lawyer who appreciates the risk is risk averse, not all of them, but frequently. And then goes on to become a judge. You want that person making choices and standing in the shoes of a director or officer saying, oh, you should have done this. Oh my God, I would have never done that. That's way too risky or whatever, right? You don't want that. And the judges know they're not business people. So when you read the Ford case, and the judge literally says, I'm not a business person. He means it, he's not. And you don't want him standing in the shoes of a business person. So we call it the business judgment rule because we're saying, even when we're thinking of these legal issues, breach of fiduciary duty and liability and these legal issues, it's your business judgment that's going to be given a lot of deference. So if you're exercising your business judgment, we're going to be deferential to that because it's very clear that it was negligent or faulty purposely. So a quarter shareholder cannot substitute their own judgment for that of the decision maker. I would have never done that, right? For that of the decision maker. And the managers or the decision makers, the officers, the directors, decision makers are protected from liability if they can satisfy this test. So if they can prove these three items, they're not liable. Their business judgment, it will be determined to be sound and okay, even if it results in some disastrous outcome. So first they have to establish the officer or director made an informed decision, which requires a reasonable investigation. We solved it on the last slide too, reasonable investigation. It's a theme, something we probably want to talk about on our exam. And in life, right? Investigating is good. Requires a reasonable investigation, which usually entails hiring experts. Those of you who want to go into consulting, you are experts. You are that outside expert that they are going to call in to look at the books and XYZ issues, right? That's what consultants do. They're these outside experts. They have no conflict of interest. They'll have to prove they have no conflict of interest. So they make an informed choice with no conflict of interest. And under here is like a sub-point. If the director or officer is a shareholder of the corporation, of course they are going to benefit as shareholders of the corporation, and that's fine. That's not a conflict of interest. So they may have a personal interest in the outcome, but it's because they're also a shareholder, and that's okay. Other shareholders also have an interest in the outcome. So this does not constitute a conflict of interest. The conflict of interest could be engaging in a transaction with another entity that they have an ownership interest in and not disclosing that, having it be unfair, all those examples we went through the previous semester. And third, so they have to establish all three, it's an and rule. They have to have a rational basis for believing the decision is in the best interest of the corporation. Rational basis, reasonable, it's at a reasonable person standard. Does this make sense? Could this make sense? Could this make sense? And it's not what I think is a good idea or what you think is a good idea. Is this rational? Is this rational? Can I see some logic to this choice, right? It might not be my logic, but can I see some logic to this choice? Is it rational? So that's the business judgment rule. It's used as a defense. So here we talked about conflict of interest, so I want to get a little more into that so we really understand what this means in this context. So here's some law on it. So as agents, right, directors and officers are agents of the corporation, and that's why we use agency theory. So they're the agents and the corporation is the principal. The other corporation duty is loyalty, including a duty not to self-deal. So that's a conflict of interest. If a director has a conflict of interest, a court may void the transaction with the corporation if it's unfair to the corporation. These are general, broad statement. What do you mean unfair? Does it have to be a financial loss? Not necessarily. It could be putting in a position in some other context, right? It could be injurious to their reputation. It could be limiting competition. It could be foreclosing of opportunity from hiring excellent workers, whatever that might be. Unfair is a very broad term. And what you look at in order to establish this fairness is what we call the intrinsic fairness standard. It's fair. It's fair if a reasonable person in an arm's length bargain would have bound the corporation to it. Would a reasonable person, not this director, just a reasonable person who has no interest in any of this, in an arm's length transaction, remember we talked about that last class, an arm's length, adversarial on opposite sides of the conference table, on opposite sides of the bargaining table, would have bound the corporation. Would they have made this choice? So this is how we can analyze whether or not there is a conflict of interest. These two bullet points can be taken and inserted into your rule statement for how we determine if there's some sort of conflict of interest, right? We talked about it here. So if your analysis calls for a discussion of conflict of interest, you probably want to explain what that is and what it means and how you can prove that there is or isn't one. So you would go deeper into this topic. Okay, so you're going to expand and provide rule statements for areas that facts direct you towards. Okay, so we went through the duty of care summary last class. We started with it. What we did after that was the infill and the background. But you guys have already done the reading, and so you're ready for that. Now, the duty of care summary, it endeavors to put into some sort of flow the decision-making and the analytical framework for discussing these breaches of fiduciary duty issues for officers and directors. Now, do you always start at the top? Do you always have to start at this rule? I mean, most likely would make a lot of sense. If you're in a situation where you have a very discrete fact pattern, and maybe you cut straight to one of the other elements. But I think that starting at the top always is a good choice because it forces you, for example, to analyze in the context of this fact pattern in this corporation, this director owes a duty of care as a chairman of the board or as a member of the subcommittee or whatever it is. You'll talk about what that person's role is, and that helps frame the discussion. So starting at number 1 helps frame the discussion. So I'm not going to go through this again. And we're going to cut straight into shareholders. We're going to talk about shareholders in this context. Oppression, that's a term we've used in past classes. And then we're going to get straight into shareholder-driven lawsuits and the impact on shareholders in Chapter 44. So we're going to cut straight to that and see where we finish up. So, oppressing minority shareholders. It's putting those minority shareholders in a position where they're unable to obtain the benefit of their investment. Their money's locked in. Like when you're a shareholder, it means you bought shares. You separated yourself from your money in order to get shares, right? So your hope is, what's your hope when you buy shares?
Profit.
You have to get a profit, right? But you only realize that profit when you sell the shares. So in the meantime, what are you hoping for? Dividends, right? So that's our Ford case. That's our Ford case. The shareholders wanted dividends, and they wanted more dividends than what they were receiving. They felt they weren't receiving the benefit that they should be receiving as shareholders. So that's one way that we can say they're being oppressed. Courts treat oppression the same way as they treat director self-dealing. So when they try to figure out whether or not shareholders are being oppressed, they go through that very similar analysis of the director's behavior and actions. So was the transaction fair to the corporation and to the minority shareholders? We look at that intrinsic fairness standard, that same test we looked at previously. Would a reasonable person, disinterested person, have bound the corporation to this in an arm's length transaction? Would a disinterested, reasonable person have bound the corporation to this in an arm's length transaction? Is it intrinsically fair? And you consider now both the corporation, and now you're adding to that the minority shareholders' interests. So here's an example. The directors and majority shareholders of a close corporation, so then it's a small corporation with few shareholders, right? Kind of like those family businesses or a couple friends get together. So it's a close corporation. They pay themselves a large salary and refuse to pay dividends. The minority shareholders have no market for their shares. Sadly, they're locked into an investment that offers no return. So that's an example of oppression of minority shareholders. Why do they have no market for their shares? Close corporation, and because it's a close corporation, what? Yes?
It's probably a family business, and no one even knows they exist.
Mm-hmm. Yeah, and if they go into the open marketplace and like, hey, you want to buy into my family business? No, I mean, maybe if it's a really profitable large, if it's Keys, auto business, right? I know that family. I would totally buy into that business. Not only are they a lovely family, but they make a lot of money. I would buy into that. But that's the only family business I can imagine wanting to buy into, right? Because you're also buying into the drama, you're buying into that kind of management dynamic that extends beyond just that entity management dynamic. You're getting into like the family management dynamic. It's very difficult to go to the marketplace and get someone to buy into a close corporation. So it's not that there's no market. It's, no's a little extreme, right? You don't always want to be that extreme. There's very limited marketplace.
So what would happen in that case? Would the directors have to lower their salary and then offer dividends? Like in this example.
Okay, so if you were the shareholder, what would you do? What would you want?
I would ask them to give up lower their salary and probably pay dividends or buy my shares out.
Right, so you would go and you would petition the court, and you would say, hey court, they're paying themselves more money than I think they should, and it's to my disadvantage, they're not paying dividends. In order to get into court, we have to have a ticket, right? We have to have that cause of action, that legal theory that gets us in the door. So what would you call that? What would the rule you use be?
With oppressing minority shareholder.
Yeah, so you feel like you've been oppressed as a minority shareholder, and that injury arises within the framework of what type of case? What are you suing them for? Yeah, breach of what kind of duty? Breach of fiduciary duty. So that's a good question, and this is an important exercise, and everyone remember it, right? Because you identify in your fact pattern when you're going along, just like we did in the last class, and I was like, okay, what are you going to underline and why? You're going to write oppression of minority shareholders. But oppression of minority shareholders is like a symptom of breach of fiduciary duty. It's one of those awful things that happens when you breach your fiduciary duty. So you can't just go to court and write, I'm suing you for oppression of minority shareholders. You are, but the cause of action is called breach of fiduciary duty. So you see how that falls within this analysis? So that's why it makes sense that we treat it the same way as self-dealing. We treat it the same way as any other breach of fiduciary duty. Are these decisions fair? They have a duty to manage, and you go through your duty of care summary. It's breach of fiduciary duty, so you go through your duty of care summary. That's, multi-element thing we went through. Your question? Yes?
I was going to say, wouldn't there be something like for when they first gave up equities, get their shares or whatever, how they distinguish that at the beginning? Wouldn't there be some kind of guidelines or promises made or something?
Yeah, and where do we find that? So where do we find the terms of understanding that contract between the shareholder and the corporation? Shareholder agreement?
Yes.
These are a few places. The bylaws, the operating agreement of the corporation, right? So technically it could be in the articles of incorporation, but we know we've seen that. Those are public. The corporation's not, we're going to put as little information there as possible, so we'll just use that web page form. That information will be in the shareholder agreement, the bylaws, the operating agreement of the entity.
I was just But if that agreement or whatever it was listed, said that they had no obligation to ever pay dividends or I guess maybe give up their salary to give it to the shareholders, if there's nothing in there, do they have any say?
Right, okay, so if the agreement is silent as to when the shareholders are entitled to dividends, is that what we're saying? So it doesn't say whether or not they should get dividends?
I
Or
mean,
does it say, because it goes
either
both
way,
ways.
either no
Okay.
dividends or there's no time frame on when they should give dividends.
Okay, well, yeah, then it's left up to the business judgment of the directors, right? What's in the best interest of the corporation? And in light of the fact that the general understanding is that corporations exist for the sole purpose of creating shareholder value. So you're using your business judgment rule to make choices in the best interest of the corporation, and then we're going to add to that the extension that we learned in our Florida case of when the judge clearly said, and it's in the chapter as well, that corporations exist for the purpose of creating shareholder value. So against that framework, and you're supposed to be creating shareholder value, and I'm a shareholder, and I'm not paying dividends, and you're paying yourself a lot at my expense, is there a breach of fiduciary duty? Now, if the operating agreement or the shareholder agreement, whatever it is, said that dividends will only be declared in XYZ circumstances, and those maybe were more difficult to achieve, but that's what it said, and the shareholder, having read that, still signed up for that, well, we're not going to protect them from a bad bargain. I mean, if they're grown adults with money, with capacity to contract, we're not going to protect them. But it's when there's an ambiguity that we're going to look at this fiduciary standard, yes?
So, this is stating right now, it reminds me of after 2008 and following these CEOs got huge bonuses while everybody else suffered and lost money. Wouldn't that have been some kind of lawsuit?
Yeah, and there were a lot of lawsuits about that. But it's hard being a CEO. I mean, like, if you don't get your $5 million bonus when your company is in bankruptcy, it's hard.
So what ended up happening?
And I say that because we would be litigating and, like, you know, I was at the firm, was filing these class action lawsuits against these firms, like Radio Shack, for example, is one of the defendants, and they declared bankruptcy in the middle of the lawsuit. And I'm like, and we're watching the financial downfall of that, and I just read an article about another company that's in bankruptcy, and the bankruptcy judge just approved bonuses. The company's in bankruptcy, it cannot pay bills, and the judge just approved like millions of dollars of bonuses to the executives.
Doesn't make sense to me.
Somebody got paid?
Business judgment rule.
Maybe.
I mean, yes, yes.
Or they could use the argument to keep their CEO level, or their executives kind of in the company and keep the company from losing even more value by everybody leaving. They had to give a big bonus.
Yes, right? Market forces. So what does the market dictate? What are people getting paid? I mean, right now, because we're in college, and everyone in college is broke, we're like, that sucks. But in 10 years, when you're the CEO, you're going to be like, I'm sorry, but market forces dictate that I'm going to get this $5 million bonus. And if I don't get it, I'm going to go to this other company. And you need me because of my name and my expertise, whatever. So you're going to totally change your mind and your position on this when you're the CEO. But until then, it's like, what about the shareholders? What about the shareholders? So it's always two sides, and thank you for bringing that.
So there is still a market though for their shares, right? Because the company would buy it back.
It's public, like in the cases we're talking about, we're just talking about some public entities, so there's always a market, but in the context of what?
Well, like a close corporation, if you had some of their shares, they would just be forced to buy it back then, right? Because they can't just force you to hold it, right?
Well, yeah, they can. So remember when we learned about the different like buy-sell agreements and stuff, unless there are terms written into the shareholder agreement, it could be that the shareholder can't force the corporation to buy the shares back. It could be that, and then that's why they go to court. They would go to court saying, like, I'm locked into this investment, and force them to buy me out. What they're doing, XYZ, is a breach of fiduciary duty because it's oppressing me as a minority shareholder, and one of the remedies I want is compensation for my shares, or I want them to declare dividends, or I want them to repurchase the shares at market value, or whatever it is that they want. That's the remedy that they're going to try to get in court. If they don't have, I mean, you can't force someone, I mean, absent going to court, right? You can't force someone to buy back your shares if it's not in the shareholder agreement, if you don't have that contractual right. So the rights that you have that are attendant to your shares and whether or not you can get the majority shareholder or the corporation, whatever, to purchase them back, that'll be in the shareholder agreement. And we have those 4 different ways that the I'm gonna remind you to go back and look at this. Okay, so that's an example of shareholder oppression. Torts and crimes. So we've learned a lot about these torts and crimes, on all these bad acts. So we're always liable for our own torts and crimes. It doesn't matter where it happens. If it happens at work and I commit a crime, I'm liable. I just happen to be at work when I do it, right? So we're always liable for our torts and crimes. It's possible that the entity might be liable as well. We already learned about respondent superior, right? So was it in the course and scope of performance of your job obligations? That's when the entity might be liable. But now when we get into this context, we can also be liable personally. Like if I'm the director of a corporation and I direct someone to take, to falsify documents, etc., right? And they're following my instruction and they commit that crime. They're the ones that falsified the documents, but I too could be liable because I directed them to do that. So not only are the directors and officers liable for their own torts and crimes, but if they authorize, aid, or abet, or conspire with others to commit a crime, even if their signature's on it, they can be liable for that as well. You're not, other than that, other than this aiding, abetting, conspiring, directing, you won't be liable for the torts and crimes of other employees unless you are engaged in that somehow. So, when can criminal liability be imposed on a corporation? So you can't jail a corporation. It can be subject to extensive fines. So criminal liability can be imposed, however, on the corporation where the criminal act is requested or authorized or performed by these top people. So the board of directors or an officer or some top employee that formulates company policy, some high-ranking employee with supervisory responsibility. Things come up with like the Volkswagen emissions scandal and other reprehensible corporate bad acts. Who's liable for that? The corporation would be found legally responsible. Wells Fargo, that huge issue. Who's liable for that? And how do we establish corporate liability? When can that corporation, which is intangible, you can't hug it, right? It's a legal person, but it's not an active person. I can't put it in jail. When is that corporation liable? If these high-ranking officials have caused it to engage in some unlawful activity, the corporation itself can be liable. So this slide talks about when the individuals, these high-ranking individuals can be liable, and also when the corporation can be liable as a result of the individual's bad acts.
Is it all of those individuals?
All of these individuals, yeah. So
it's not all of them for the corporation to be.
no, so any one of these people. So when we determine whether a corporation should be liable for some criminal conduct, we're going to look at who was that bad actor, who authorized this. Because the corporation acts by and through its humans, right? So which humans authorize this? If it was someone at the top, board of directors at the very top, or an officer, they're at the very top, then it's easier to satisfy that burden. Like you're leading the charge. You're the human leading the charge. But it's not always that high up the ladder. These huge entities, it might not be those people at the very top making the choices, but there's someone responsible for formulating this policy. Maybe it's the head of finance who's forging these SEC filings, or a high-ranking employee who's responsible over that particular topic. So the whole point of these two bullet points is that we have to get as high as we can in that corporate structure. So it's the highest person dealing in this realm. It's not a director or an officer, it's the highest person dealing with the decision-making that was unlawful. And if it's not the highest person, if it's just an employee, say some employee is doing some bad acts, well, that employee is like a mid-level manager, and their behavior is just going to be their bad behavior. It's not going to bind the corporation. So the point is the corporation is only bound when the highest of bad actors makes the bad choices. That's when the corporation gets criminal liability. Yes.
So it says that they authorized it, like they participated in it. Does that include people that kind of knew something was happening and then just looked the other way, or?
I mean, so that's why they've changed the rules recently, for example, with regard to like SEC filings that require more of the officers to sign off on them, so they can't say that they didn't know. Looking the other way. Like, it wasn't technically unlawful for them at the time, and we don't come up with these laws until we realize, oh, oops, we should make that illegal, and then retroactively after the fact, after Enron, we decide, okay, people are going to have to certify that they saw it, so we can't say that they didn't. They can't stand their head. Okay, so indemnity. We're just talking about now how they can be liable, but they're going to work. They're going to work. They're doing maybe the best job they can. Maybe they're doing, purposely engaged in fraudulent activities. Who knows? At the end of the day, these people are going to work, and this is where they're encountering this liability exposure. So because they're at work, could they possibly get some indemnity? Like say someone sues them, who's gonna pay for their attorney's fees? Does it have to be them? Or because they encountered the situation through the course and scope of their employment, will their employer pay for the legal fees? Who's gonna handle this? So because officers and directors have a risk of liability, corporations often indemnify those who serve as a director or an officer. So indemnity. Indemnity means to protect against. So to protect or insure, it refers to the practice by which a corporation will pay the expenses of the officers or the directors who are sued in litigation. So if an officer or director is sued, as long as it's not for fraud, the corporation will generally step in to indemnify them. If it's for fraud, insurance is not going to cover that, so they're not going to cover the expense of that defense. But attorneys are really expensive. So when I was practicing, it was a real estate position, but it was in the context of corporations, like corporate clients, and we had some bad actors. Allegedly, they're my clients, so obviously they didn't do anything bad. But we had these individuals would be sued for breach of fiduciary duty, and they would be insured against that, right? And so their insurance carrier would step in and start to pay their legal fees. And I would have to report to the insurance, I'd have to analyze the case, report to the insurance carrier what I thought the potential liability exposure is, get them to assess what they'd be willing to pay to settle, and then talk to the client. So you're engaging with both of these to try to figure out what's the case worth, did they really engage in some bad acts? Was it fraud? If it was fraud, the carrier's not going to pay for it. If it's not fraud, the carrier will pay for it. And so now you have this individual who's not paying their fees. We had situations, one of my last cases, for example, there were breach of fiduciary duty claims lodged against my client in addition to fraud claims. And it was kind of in the same case or controversy, the same fact pattern, and I had some competing interests. The insurance carrier didn't want to pay her fees, and she wanted, obviously, for them to pay. So we had to broker this deal, say, look, you're settling, and when you settle, you don't admit liability. But this case was kind of leaning strongly towards fraud, and so maybe our individual is going to have to pay X portion of the settlement from her personal funds, and the carrier would pay another portion of the settlement because I didn't go to a jury, we didn't get a finding of fraud or negligence, which what it was. So we had to kind of mediate that, because they were not going to pay for fraud. But they indemnified up to a certain amount. So that's what it really is. It's will the corporation, usually by through an insurance carrier, pay for the defense of the defendant when they're sued? Or do they have to pay themselves? My client was not happy to have to dip into her pocket for even 6 figures to settle her portions. She wasn't thrilled, but it was way better than to experience the trial. I wish I could tell you that story. Okay, come to my office. Directors will be indemnified where? So here's how we determine whether or not to indemnify directors, how to indemnify these corporate actors. Did they act in good faith? Did they reasonably believe they were acting in the best interest of the corporation? And if the indemnity is for a criminal fine, it's criminal, not just civil penalties, right? A criminal fine. Did the director have a reasonable belief that it wasn't unlawful? You have to prove that they knew it. They thought it wasn't unlawful. Is it reasonable for them to think this is not illegal? Is it reasonable for them to think this is not illegal? So that's the one criminal case that we briefed as a class that people were like, what is this case about? One of the requirements was that she proved she didn't know it was illegal. That's where this comes into play in order to be indemnified. Act in good faith, you believe you're acting in the best interest of the corporation, and if it's criminal, you didn't have any reason to believe it was illegal. This is really difficult.
For all the tests, it seems like there's a continuity with first rule being good faith, second rule best interest for the
Yes.
corporation.
Yes, exactly. And so if you don't know what to write, that's what But it goes towards that fiduciary duty. You're fulfilling your fiduciary duty. If it's that highest good faith, fair dealing, putting the interests of the principal before your own. So if you're doing that, then the fact patterns can differ so broadly. This is so broad that it captures all these different fact patterns, and it comes up again and again and again. And you're right. This is just showing you in various contexts how you analyze this little offshoot of the topic and this little offshoot of the topic. It's all the same analysis. So we are going to jump into chapter 44 as revised.
Where we left off, that's what we focus on.
Where we leave off is where is the questions, it's likely that one of your classmates has the same question. So send it to me. And if you'll probably see it posted as an announcement, I won't identify who you are, but I'll post that information as announcements. So if you see announcements coming out closer to the exam, it's generally because I received a question and I want to make sure everyone has the same information if I think it's material. So watch out on campus for announcements and stuff. And don't feel like nervous, or sometimes students hesitate to like email me questions. Don't do that. Okay.
Well, just days after investors handed over billions of dollars for stocks in Facebook, today some of them gave the company and its underwriters something else, a class action lawsuit. CBC's Keith Bogue explains why.
Back up, guys, back up. This was Facebook CEO Mark Zuckerberg in Manhattan a couple of weeks ago on a tour talking up the stock in his company. Facebook's initial public offering, or IPO, was just over a week away. It was at this time the company filed an amended prospectus with the Securities Exchange Commission. The amendment said the economic outlook for Facebook might not be as rosy as previously thought. That was important information most investors didn't know about.
Facebook's mission is to make the world more open and connected.
Whether Facebook itself was being open about its prospects is what will be the subject of a class action lawsuit launched by disappointed and disgruntled investors who say they were kept in the dark about what had changed at Facebook. Investment bank Morgan Stanley, Facebook's underwriters, is also named in the lawsuit. They knew about the amended prospectus, but apparently told only a select group of their most privileged customers, and at least some of those customers acted to save themselves from making a bad investment. But many investors were not told of the sudden clouds in Facebook's future, which means the playing field was tilted.
Either everyone or no one, and if there were some voices of skepticism, especially seeing how things have gone, I think everyone should have heard those.
You can't tell me there isn't one investor in that Facebook IPO that wouldn't have wanted to know that information.
Since the IPO last Friday, investors have lost nearly $3 billion as the stock plunged. Today, Facebook responded saying, "We believe the lawsuit is without merit and will defend ourselves vigorously." This isn't just about Facebook. Even if it turns out that everything about the Facebook IPO was legal, it still leaves the impression that Wall Street has an inside track and that most of us are not. Keep on CBC News, Los Angeles.
I mean, it's so surprising to hear something negative in the news about Facebook. I like to start off with this because it's short and sweet. We all know about Facebook. And it's all about information. It's all about information. So when it comes to like especially publicly traded corporations, the reason why we started our corporation segment with going and looking at the filings is because I wanted you to see what that looks like. That's what shareholders have to turn to determine whether or not they want to stay invested in this entity or whether that they want to buy stock, right? So it's a prospectus before you go public, right? You issue your prospectus, and it looks very similar, though. It talks about, the financial standing, what your plan is. Remember the highlights that they put on the screen from Tesla's quarterly filing that talked about how a lot of our success will depend on how we manufacture this car. And then a couple paragraphs down, we have no experience in manufacturing this car, right? They have to actually give the honest feedback, and so people can look at that and say, do I want to buy into this? Do I want to be a part of this? I need to make a meaningful choice. Because just as we expect directors to investigate, right, the shareholders do, everyone should be investigating and doing due diligence. So with Facebook, it was a huge controversy right when their IPO came out because they had their prospectus, and which goes out to all the potential shareholders. People decide whether they buy in. Everyone's all excited because it's Facebook, and everyone's on Facebook, and they're excited. So all these people buy in and they want to get into the IPO. They think that all of a sudden they're going to buy at this low price and then the shares go up and they're going to get money right away. But what happened is they filed a prospectus just days before they went public and no one knew about it. Like no one's trolling the SEC website every day for Facebook's filing, right? No one's doing that. So no one knew. No one knew. The only people that knew were Facebook's people at Morgan Stanley and who happened to tell their high-end investors. And those high-end smart investors decided to pull out. So I'm wondering, they thought that was a smart choice not to buy. But they didn't share that with other people. Why didn't they share it with other people? I don't know what other people pulled up too. Would have been a mess? Yeah, it would have been a mess, and this is a mess also. So sharing information. Sharing information. There was a big class action lawsuit because people lost money right away. You don't expect to buy stock and then lose money right away. It's not what you're signing up for. It's kind of like people who own, I know people who own Apple stock, people who own this like old, you know, these old companies, and they buy the stock right at the beginning or early. I got in early, they say. Why is that exciting? Because when you get in early, you pay less. Like that's the point, right? Is that you pay less and then it goes up. So I'm getting in early with Facebook. Oh, right. This talk lapses, $3 billion are lost. So that turned into a lawsuit. So it's a perfect example of shareholders being misinformed, having their rights violated allegedly, and not being able to make informed choices. So there's shareholder oppression, which is when they're unable to maneuver, they're unable to get the benefit of their investment, either to buy themselves out, to sell their stock, or to get dividends, or otherwise receive the benefit of being a shareholder. And then there's this like disinformation, another way that they can be injured. So shareholders own the corporation, but they have no right to manage the corporation. The only power they have to really impact what the corporation does is when they're permitted to vote, when those issues come up that they're permitted to vote on, or when they can choose to vote in a director who they hope is going to make choices that are aligned with their goals, or if they want to see some massive change and think it's going in the wrong direction, they can bring legal action. So here are the powers and duties. They elect and remove directors, they vote on important issues, they have to pay the promised value for their shares. That's one thing they'd be held liable for, with all that a few chapters ago with our example. They have to pay the promised value for their shares. And controlling shareholders owe duties to minority shareholders. So minority shareholder question is a big thing. If someone owns 80% of the corporation and there's a couple minority shareholders holding 20%, we expect and demand that those majority shareholders are going to make choices that don't harm the minority shareholders. And if you think about it, I mean, they're going to vote. They all have the right to vote, but minority shareholders' votes almost don't count, right? Because they're in the minority. They will always be overruled by these majority shareholders. I mean, they have votes, but they don't count. They count, but they'll lose. So this is why we impose this duty on the majority shareholders, because every time they're going to get their way. Every time there's a vote, they have a majority. They're going to get their way. So they owe a duty to minority shareholders. The lawsuits. This is the part of the chapter that I brought forward to the front because we're in a law class. So shareholder lawsuits. The shareholders can sue personally in their own name for personal injury, such as to recover dividends or to enforce their right to inspect the books. So that's the shareholders suing in their own name to enforce their personal rights. I'm not getting dividends. I'm being oppressed. I want you to buy my stock back. Or I want to look at the books. You're not permitting me to look at the books. That's their right. So that's two kinds of lawsuits. Their own name or a class, three kinds of lawsuits. A class action, a shareholder class action lawsuit, not a derivative one. A shareholder class action lawsuit is still a lawsuit brought by the shareholders in their own name. It's just that now a bunch of them got together. So it's still a lawsuit brought by shareholders in their own name. It's just that a bunch of them got together because they have the same injury. Maybe there's a lot of shareholders that are not getting the dividends, and that's what they're pursuing. But it's that personal shareholder injury, and there has to be enough shareholders here that a class action is judicially economical. So, you know, you're talking more than 15, more than 20, usually around 30 is a satisfactory number. It has to be so many shareholders that if they each brought their individual lawsuit, then that would put a burden on the court, right? So class action is supposed to bring people together so you can litigate all of this at once. So shareholders pursuing their individual claims. Now a shareholder derivative lawsuit, again, derivative, someone had said extending out from or something, that definition someone gave in class a couple weeks ago. A shareholder derivative lawsuit is brought on behalf of the corporation. It's derivative of the corporation's rights. So the corporation has been injured and the right to sue belongs to the corporation. The shareholders they're not suing to recover their dividends or to look at the books or to enforce their own personal shareholder rights. I see the corporation is losing a lot of money, you're making bad choices, I don't agree with what you're doing, you're breaching your fiduciary duty, so the corporation is suing you, board of directors, right? The board of the corporation is suing you. So the right to sue belongs to the corporation, and any recovery, any damages that are gained in that lawsuit go to the corporation. The derivative suits may be against individuals within the corporation or outsiders. So it can be against maybe the outside consulting firm that did some really bad acts and it resulted in some damages. Maybe they created some fraudulent reports, or maybe they defrauded the corporation in some way. Or it can be against these individuals within the corporation, and who would that usually be against? Yeah.
So the outsiders would be like Morgan Stanley.
Yeah, that's a good example, exactly. Or other outside entities that have somehow defrauded the corporation or injured the corporation. Like, I think, this was a bad deal, this contract was based upon fraud or predicated upon fraud, and it injured the corporation, so we're gonna sue, whatever. Perfect example there. So derivative suits may be against individuals within the corporation or outsiders. So the individuals within the corporation are gonna be those top people, the directors, the officers. The requirements, in order to bring a shareholder derivative lawsuit, now, sometimes there are people out there who want to bring lawsuits because they want to get money, right? So we have to make sure that we have a proper plaintiff. We call this as a proper plaintiff. So when are you a proper plaintiff? When do you have the right to bring this shareholder derivative lawsuit? Because if it's shareholder derivative, we're talking corporations, we're talking a lot of money, And you generally, plaintiffs can get some sort of like special payment for pursuing this for their time. So people are incentivized to bring lawsuits. So we want to make sure we've got a proper plaintiff. So when is that a proper plaintiff? Well, they have to be a current shareholder who held shares at the time of the injury. So not only do they have to have shares at the time of the lawsuit, but they can't just buy shares so that they can go sue the corporation. They have to have also held those shares at the time the injury or bad act occurred. They have to prove that they are, they can fairly and adequately represent the interests of the shareholders who are similarly situated, so that they don't have interests adverse to those other shareholders. They have no special agenda. They're in the same situation as all the other shareholders. The only difference is they have the time and desire to help bring this lawsuit. And they have to first make a demand on the board of directors. So they have to go to the board of directors and say, hey, I noticed that this terrible thing is happening, or I noticed that this corporation has defrauded us, or the corporation, or whatever, and we think we should bring this lawsuit. The board of directors can say no, or they can say yes. If the board of directors says yes, then it goes to the subcommittee. There's usually like a litigation subcommittee on the board of directors, and they would go hire the attorney and bring the lawsuit. If the board of directors says no, then that's when the shareholders can go ahead and proceed. So if the board agrees, the shareholder may not bring the lawsuit. Because the board of directors, it's the corporation's rights and duties, right? The derivative lawsuit is the corporation's interest. So if the corporation, through the board members, agrees to sue on its own behalf, then the shareholders don't have the power to do it. Because it's the corporation's rights, and the corporation, through its humans, right, its directors, is suing. So if the board agrees to sue, the shareholder may not bring the suit. If the demand on the board would be futile, because, for example, the shareholders proposing that the corporation sue that board of directors, well then, of course, you can just prove that it's futile, and you don't have to make tender that opportunity to the board.
Going back to the Facebook example, not only would the board or the executive or whichever Facebook cause the injury to, I guess, the minority of shareholders, but also be the privileged, the well-informed shareholders be also liable, since kind of similar to like Martha Stewart's case. Or she knew the stock, the trends, and she was able to sell it and make a huge profit, but that was a criminal.
Yes, yeah, she was insider trading. Yeah, Martha Stewart. She recovered from that so well, right?
Yeah.
I mean, still throws good parties. Okay, so, but that takes us back. Hold on. So, the people suing in that Facebook case, what kind of case do you think that was? Do you think that was a shareholder derivative lawsuit trying to protect the corporation's interests, or was it shareholders trying to protect their own interests? So, it's a class action. Yeah, it's a class action lawsuit. Like, so you have to first apprise like the injury, and then figure out, okay, who's injured and who's going to advance that thing. They talked about the $3 billion that the shareholders lost in value. They're out of money. Their stock is worthless, so they're going to get together as a class action and proceed. But they're not interested in pursuing the corporation, any damages to the corporation. Okay, if for some reason reason the board of directors decides to take on the case, the shareholders go to the board and say, hey, the corporation's been injured, I'd like to file a shareholder-driven lawsuit, and the board of directors says, wait, you're right, I see it, we're gonna go ahead and file that on the corporation's behalf, so go away, shareholder, we're gonna do it. The board of directors will create something called a special litigation committee. They'll evaluate the shareholders' stand, determine whether they're gonna sue, and if they decide to sue, then they're gonna hire their lawyers to proceed. They can also decide whether to ask the court to dismiss previously filed shareholder derivative lawsuits. If a shareholder proceeds and files a derivative lawsuit without tendering it to the board, and the board hears about this, they can say, no, dismiss that court, we're gonna take it on, or dismiss that last merit, so they can defend that lawsuit. Alright. This is how we disincentivize people from bringing lawsuits that are frivolous. If the shareholder loses, they must pay the defendant's legal fees. If the shareholder loses, in this context, they will have to pay the defendant's legal fees. So if they go ahead and sue their corporation, they bring derivative lawsuits, it's very expensive to defend against that. They have to pay the fees because they've injured the corporation because the corporation has had to pay attorneys to defend this. However, if the shareholder wins, the corporation must reimburse the shareholder for the legal fees. And if a derivative suit fails and the court finds the suit was brought without reasonable cause, the shareholder must pay the defense legal fees as a definition of that. And this is to punish those shareholders who litigate in bad faith. A lot of times what happens, unfortunately, there are some people with just bad motives out there in life, everywhere, not just in the law, especially in the law, but everywhere too. Not especially in the law. So there's a lot of different areas of law where plaintiffs just go try to dig up lawsuits. There are people in like disability rights law that will go into different places and say, oh my gosh, this isn't compliant with your hallway is not long enough, or you don't have these different requirements in order to accommodate people with disabilities, and they'll sue, even though they would have never gone there except for they were looking for someone to sue, right? There's always cases on it. This one woman in Arizona filed like 90-something cases against different establishments, just looking for lawsuits. So it happens. And so because it happens, and it especially happens against defendants with deep pockets, you find a defendant with a deep pocket, they can pay. They can pay nuisance money to make you go away, which is a lot of money, or they can pay if there's damages. So people try to rile up these lawsuits. So this is a way to combat that and to punish those shareholders who do litigate in bad faith. But you have to prove that there's no reasonable cause. It's okay to lose. It's okay to lose. But if you lose and there's no reasonable cause, you're paying. Okay, so where do shareholders vote? We talked about this at the annual meeting. We saw an example of the annual meeting on the Tesla video, what that might look like. There's a notice of the meeting. The notice is required. It has to say time and place. The same quorum concept applies to shareholders as it does to directors. In order for the entity to make a meaningful choice, it has to be sufficiently represented, right? So think of how you make meaningful choices, and when you're in a place to make a meaningful choice, it's not like half asleep or before your morning coffee or whatever. You have to have like enough of yourself present in there, right? So it's the same thing with these entities, the quorum concept. Quorum, for purposes of shareholders, is a majority of shares outstanding. Don't forget our share terminology, outstanding, issued, treasury, right? So the outstanding, the currently outstanding shares, a majority of those have to be present in order to make a choice. And then generally you take whatever's present, so maybe you have 80% present, that's clearly a majority. So then it's a majority of that 80% to pass a resolution. Okay. I'm just thinking about where I want to move you. Okay. Okay, so where do shareholders vote? It's at a properly noticed annual meeting. The meeting has to specify a time and a place because shareholders want to exercise their right to vote, so they have to let them know when and where it's going to happen. You don't have to know a lot of, the book gets into a lot of specifics, but I want you to know for purposes of your exam when it comes to the shareholder voting issue, and pretty much for this chapter, because I know it's new, and is this. So the lecture plus the PowerPoint, the book really complements it, so you've got a mastery of it because you've read the book and you're so set. But you should be able to accomplish an acceptable performance based on the lecture and PowerPoint. But again, the book's going to get you a little further. How does voting work? First, there has to be quorum, a meaningful percentage of the humans there to make the choice. And then the action is approved if the votes cast in favor of the proposal exceed the votes cast against the proposal. So X Corporation has 120,000 shares outstanding. 80,000 shares are represented in the meeting, but only 50,000 shares vote on a particular proposal. How many shares must vote for the proposal in order for it to be accepted by the shareholders? First, do we have a quorum? Before we get to, did the vote pass? Do we have a quorum? Can we even make a choice? Yes. Okay, because we have 120,000 shares, 80% of that is clearly a quorum. And so now, what do we need in order to pass? Now, the number we think about is this number. That's how many shares are voting. So these are the shares voting. Now, what do we need in order for it to pass?
41.
So you just need half plus 1, right? So 50,000 shares, which is clearly in excess of that, votes for it. Votes on it, not votes for it. So now we have 50,000 shares voting on it. How many shares must vote for the proposal in order for it to be accepted? So first we get to, do we have a quorum to make a choice? And then we get to, we have some abstentions. We have 30,000 abstaining, withholding their vote. And I'll give you an example of an abstention in a second. So we have 80,000 present, 30,000 are holding their vote back. They're not voting on this. We have 50,000 voting. So how many have to vote in favor? If a quorum is present, actions approved if the votes cast in favor of the proposal exceed the votes cast against the proposal. 1. Votes cast in favor of the proposal exceed the votes cast against the proposal.
This is like a majority of a majority.
This is like that weird law math again. And yeah, it's not, I don't know. I don't know. Take it step by step. First, figure out if there's a quorum. Once you figure out if there's a quorum, forget those numbers, okay? And then once you have a quorum, figure out how many people are voting, or shares are voting. Once you know how many shares are voting, which is this, then you have to get the votes for it exceed the votes against it. So it's not a majority of a majority, it's a majority of the votes voting for it once a quorum is established.
So, in this example, if it was for it, it would be 41. If it was against it, it would be 25 plus 1. Is that what you're saying?
Okay, my brain's confused. Okay.
Because the other, you said 41,000.
30,000 votes have abstained from voting. They've chosen not to vote.
Well, no, I just want to know the tipping points between for it and against it.
Oh, one more. So if you have 20, so these are the votes who voted on it, right? They voted for or against. So 50,000 have cast ballots. They've cast ballots. So how many ballots have to be pro-proposal in order for the proposal to pass?
41.
25,001
It's only of the people who voted.
voted.
Because
So-
there's 80,000 quorum, but they
Only 50,000 voted for or against total.
within 50,000 would be.
Okay, so you do like 2 quorums, like 120, 80, and then of the 80, you need 50.
Usually, I mean, there are other rules that I'm not going to trouble you with. Frequently, it's you have to have at least a majority voting. Like, so once you get a quorum, a majority of that number voting. Here's an example of why it matters. Like, we're just going, I want you to understand the concepts, like, and these are the basic concepts, that it matters who's there and it matters who votes. And here's an example of why. So, we talked previously about that rule passed by the California legislature, the first state in the country to do it, that is and signed by Governor Jerry Brown, that requires that corporations with of a certain size, making a certain amount of income in the state of California, to have a certain number of seats reserved for female board members, or saving seats for female board members. Now, some people argue, and I think intelligently so, there's great arguments on both sides. Some people argue that this kind of law is not necessary, and in fact it's not helpful, because they argue that the market is already addressing this issue. There are certain mutual funds, for example, who have a ton of shares, right, that are withholding votes on key corporate issues where the entity doesn't have a sufficient representation of females or other classes on the board. So if we have entities within the market who have a substantial stake, who are making choices to withhold votes from corporations, the corporations can't make fundamental changes like mergers and stuff like that if they don't have a quorum, if they don't have enough people voting, that impacts the corporation. That's market forces, right? So market forces are already having an impact, and you can go read about some of the mutual funds, et cetera, that are withholding votes. There's some really cool articles on that. So if that's happening, do we need the government to step in and also to legislate and impose fines and penalties? I don't know. Some people think it's necessary, some people think it makes a statement, some people think it's not necessary because the market's acting. But that's an example of how we can use our power, our voting power as shareholders, to impact company behavior. And that's an example of strategy, why voting is important. If they don't show up, if they refuse to show up and they can't help that corporation reach quorum, that corporation can't make choices. There's board vacancy positions that are not going to be filled. All those things corporations do and all the things corporations shareholders have to vote for aren't going to happen because they're not even going to show up at the meeting, so there can't be quorum. And mutual funds hold huge amounts of shares. So these are the basics, and that's why it's important. But the bylaws will say more specifics. The bylaws will say, for this type of vote, this amount and this amount. Like, it's different per entity, and it'll be in the bylaws. Yes?
Is there any way to have the not present shares vote in favor if they choose not to show?
Yes, proxy. Thank you. I love that. It's like you read my mind. Okay, a proxy. So what if I can't go to a shareholder meeting? What if I can't go, or I don't want to go? Or what if, it makes a lot of sense for a bunch of shareholders to set one person to vote on their behalf, right? So that's called a proxy. So you can authorize a proxy. Interestingly, it's valid for only 11 months, right? Because it's an annual shareholder meeting. Thus, you have to do it again every meeting, right? Has to be in writing, signed by the shareholder of record, sent to the secretary of the corporation, authorizing the proxy to vote their shares. So you're basically like, I'm sending this person as a proxy, I've signed something in writing, sent it to the corporation saying that they can vote my shares, and then that person, while they're physically not there, their shares are there, and their shares can be voted, and their proxy can cast all the votes that their shares would be entitled to with that shareholder absent. So that's how most, meetings actually function, is that the proxies go and they cast a bunch of votes for a lot of shares. Now, when you are, where you have these kind of, passive shareholders who are sending in proxies, things like that, the general rule, they call it the Wall Street rule, is you either go along with what the manager of the corporation wants, so you vote you vote for the initiatives, or you sell your shares. If you're a passive shareholder, you either go for it or you sell your shares. That's the Wall Street rule, it's like a requirement, but it's like the general kind of vibe and the practice that happens. If you want to see what these look like, you can go to this website to see what these kind of proxies look like.
The proxies have to be done ahead of time?
Yes. Yes, yes, yes.
Why is it that generally go with the company or sell?
Because if you're a passive shareholder, you're not really paying attention, and you're not,
That involved?
yeah, then how are you in a position to even make a meaningful choice? Like if you're trying to cast votes against initiatives, but you're passive, you're not paying attention, you don't have the ability to make an informed choice. Like you don't have a substantial reason to be against an issue because you don't have enough information about it.
Are you
Because you're passive.
minority?
Not minority shareholders.
You could be either one, either majority, probably not, right?
I mean,
Minority votes don't even count though, so.
Everyone's vote counts, right? It's just they can be overruled, and they could be outnumbered. Passive, a lot of people like mutual funds, for example.
Yeah.
Like if I own shares in an entity through my ownership of mutual funds, I should, if I were to go to the shareholder meeting, have a tantrum, it's like, well, you don't do anything, you own mutual funds, come on. We don't want a lot of noise. So here's an example of what it looks like, proxy statement. This is one for Yahoo. So it's just notice of annual meeting, and then you can fill it out and have your proxy go in your behalf. Okay, so proxies. Okay, this is the last slide. The last slide of this class. So, classes of shares. Is that next?
Yeah, that's the next one.
Oh, did I skip? Okay, yes. Now, this is the last one for this report. So, corps can have different kinds of shares. We read about this, we talked about it. You can have your preferred shares, you can have common stock, Class A, Class B, right? Remember when we talked about electing boards of directors, how sometimes they'll reserve certain seats for certain classes of shares to make sure everyone gets representation on the board, and they'll stagger it. So if there's 9 directors, for example, and they're 3-year terms, 3 directors will come up every single year. So there's constant turnover, but there's also continuity. So there'll be different classes of shares that have different rights. And again, common, preferred, Class A, Class B. Sometimes you have a situation where only the preferred stock gets dividends. So a corp can have numerous classes of shares with varying voting rights. Each class is entitled to elect 1 or more directors. This helps balance the power of the corporation. The rights and duties and entitlements for the different classes are going to be set forth in the bylaws, so it can vary per corporation. But the most important factors include like your right to dividends, your right to vote for the directors. And that's it. Now, talking about voting, this is where I want to end on voting, because we talk about the reason what shareholders vote for. So they vote for the directors, they vote to pass certain resolutions. What type of resolutions are they voting for? When do they come together and vote? It's really only in the event of these fundamental corporate changes. Because the directors and the officers of the corporation are running the day-to-day. They're running the day-to-day. But there are some times when they need shareholder input. That's only when it's a huge thing. Like merging with another entity is not a day-to-day thing, right? That's a special thing. So that's when the shareholders have the right to vote. So merger is where one corporation merges into a second corporation. One corporation merges into the second corporation. So it's like Pac-Man, it swallows it. So there's a surviving corporation. That's the one that survives the merger. That's the one that encompasses or envelopes the other company. And then the other entity merges out of existence. It dissolves and merges out of existence. So a merger, the way we use merger, it's like merging traffic, right? Where 2 lanes merge together and become 1 lane. That is not merger and corporations. Merger and corporations is the surviving corporation is like eating the smaller corporation. It's like Pac-Man. It's not like traffic merging, it's like Pac-Man. It shouldn't call it a merger, they should call it like a devouring. But merger sounds better. But the corporation that merges out of existence dissolves. It dissolves. So the surviving corp takes all the business, assets, debts, and liabilities of both corporations, and the shareholders of the dissolved corp become shareholders of the surviving corp. And both corporation shareholders must approve the merger. So it's a different type of use of the word, and I want to point that out. But this is an example of what we call a fundamental corporate change that would require shareholder voting. And with that, you guys are so great. Exam on Monday. I'm here. You come to my office. I'm not scary in my office, I promise. So come see me, ask me questions. Today's 1:25 till 2:45, and I have to leave today at 3, but I'll be here on Friday, and I'll email me maybe Thursday afternoon.
Your next class is at 2? I don't have another class today. Oh, you don't have any classes? Okay, no. I'm gonna get some food and then meet up by Cracker Park. Yeah. The handoff. You wanna meet in the group, the computer group? Yeah.